That could always happen. There's no doubt about it, which just goes back to emphasizing my first point of this whole webinar, which is the value of practical politics. If you either vote yourself or by not voting enable politicians to be elected who will appoint justices who think that abortion is a constitutional right, they will come in and overturn Dobbs. So, as I said at the beginning, this is a great victory, but it's not a final victory. There are no final victories until the second coming. We're called upon to be actively engaged in sanctifying the world and responding to the needs of our brothers and sisters. So yes, that is a risk. And the only way to prevent it is to elect politicians who will appoint judges who have the right judicial philosophy. And I don't think, I think the right judicial philosophy is applying the Constitution as written, not as we wish it would be. Why do I say that? Because as I said at the beginning, that makes your vote count. If judges decide all these issues, you lose your vote. So originalism is the right judicial philosophy in a democracy. I mean, it's a much more solid opinion, Dobbs is, because it looks at the history and tradition of the American people. Look, but if you get a justice on the court who rejects that, who thinks that their job is to unpack the meaning of the word liberty in the 14th Amendment in light of their own contemporary understandings of liberty, they're not going to be persuaded by what Dobbs said. I think Dobbs is extremely persuasive if you agree that the role of judges is to apply the Constitution. If you think the role of judges is to solve national controversies, which the Supreme Court said it did in Casey, then you're not going to be happy with the outcome in Dobbs. And I don't think we can escape that. And I think people have to think about it. And that's why I'm saying, as the court said in Dobbs, if you read Roe v. Wade, you might think, now I don't think pro-life people would think this, but you might think that's a pretty sensible resolution. You've got these trimesters, you've got these different interests. We balance one thing against another. Well, let's assume that was some kind of a sensible resolution. That's the job of legislature. That's not the job of the courts. That's what legislatures do. They have hearings, they have witnesses, they take evidence, they draft legislation. They have to advance it through negotiations with other legislators. They get it passed. Then the executive, if he vetoes it or she vetoes it, they've got to pass it over that veto or convince the executive to go along. So that's a legislative function to come up with the kind of supposed resolution that Roe did or that Casey said it did. Remember, Casey said that it had resolved this matter and that pro-life people should go home because the court had resolved it. Well, the reason that was unpersuasive then, and the reason the court overturned it is not the court's job in a democracy to tell the people to go home. Now, the only way the court could tell them to go home was if the Constitution gives some particular power to the court, and it does not give the court this power to resolve disputes. It gives it very limited power. I mean, Justice Thomas would argue there is no right, there is likely to be no power by the court to find an implied right under any provision to anything. Although he says in his concurrence, it might be so under some provisions, but it's not so under due process. So my point is, if you don't let the judges rule you, it doesn't mean you can't, it doesn't mean the issues are gone. It means you have to rule yourself. But if you get a justice that thinks his job or her job is to tell you what liberty means based on what they think it is in 2022, then they're not going to be persuaded by Dobbs, although I think it's a great opinion.